Congratulations on your nomination. And as we usually do, you made some statements in the past that I want to make some questions to you about. Last week, we learned that the Loudoun County School Board in Virginia covered up the fact that a male wearing a skirt had sexually assaulted a 14-year-old girl in the girls' bathroom at the school. The same boy allegedly later assaulted another girl at a different school. In 2016, you argued in multiple briefs that concern about the safety of young girls in school bathrooms were unfounded. In one brief, you argued this, quote, no data or tangible evidence in support of that claim that allowing people to use bathrooms corresponding with their gender identity will lead to increased violence or crime. In light of the troubling news about Loudoun County, do you still believe that concerns about safety and privacy, especially for young girls in school bathrooms, are valid?
Thank you for the question, Senator Grassley. When I was an advocate and at the New York Solicitor General's office, in that case, I advocated the views of my clients. So we filed a brief taking a certain position. I'm not familiar with the case that you just mentioned, but what I will say is that as a judge, I know that my role is to set aside whatever it is that I did as an advocate and be guided only by the law. And that, I promise you, is what I do now and what I will continue to do if confirmed. I'll be guided by the law, I'll be guided by precedent, I'll be guided by the record before me and nothing else.
Okay. You may give the same answer to my next question, and if you want to not repeat it, you don't have to if it's the same answer. In a brief arguing against the North Carolina school bathroom law, you suggested, quote, privacy curtains and separate, also quoting, changing spaces would be sufficient to protect school-age girls from predatory acts in the bathroom. How would privacy curtains or change of spaces have prevented the sexual assault in Loudoun County? And I guess you said you didn't know much about that. It really hit the news out here. So I'm going to go on to another question. Does federal law require private businesses to provide access to restrooms and locker room facilities that align with an individual's gender identity and gender expression?
Thank you for the question, Senator Grassley. Now, that's an issue that I understand is one being debated, it's one being litigated. And as a sitting judge and as a judicial nominee bound by codes of conduct, I can't comment for you on what I think or how I think the law would resolve those issues. What I can commit to you again is that as a judge now and as a judge on the Court of Appeals, if confirmed, what will guide me is the Supreme Court precedent and the law. I take each case as they come, one by one. I look at the record, I look at the facts, and that's how I make my decision on that and on nothing else. Thank you.
In Simmons versus Galvin, you argued that a law banning felons from voting in election does not violate Section 2 of the Voting Rights Act. Do you still believe that, quote, neutrally designed and enforced, end of quote, voting laws are generally not subject to challenge under Section 2?
Thank you, Senator Grassley. The United States did take that position in Simmons versus Galvin, and I was counsel on that brief. Now, Section 2, as you're aware, requires totality of the circumstances analysis. It's very case specific. The Supreme Court has made that clear. And so any issue regarding Section 2 that came before me, I would handle in that way by taking a really case specific look at the totality of the circumstances, guided by Brnovich, which the court has set forth 5 factors for courts to consider, and that's how I would be led. So I'd be looking at those factors.
Okay. This will have to be my last question. In 2019, you reversed a juvenile court's order requiring substance abuse awareness and treatment as a condition for a drug dealer to have custody of his children. The man was found with large quantities of fentanyl and methamphetamine. He was also found with medicine to treat accidental overdose. But despite this, you found that the juvenile court had abused its discretion by requiring the awareness and treatment programs. Can you explain why it is an abuse of discretion to require drug dealers caught with large quantities of fentanyl and other deadly drugs to undergo awareness and treatment before being allowed to have custody of children?
Thank you for the question. So, as I wrote in that opinion, and it was a unanimous opinion of our panel, what the matter turned on was that there has to be, under California law, a connection between the disposition and between the actions that led to the dependency of the children. Now, in that case, I wrote that the father's actions could be the basis for a great many orders by the juvenile court, but that as substance abuse by the father was not a condition that led to the dependency. Under controlling California law, substance abuse treatment for the father was not appropriate, but the decision left open to the juvenile court further actions to address the issues that you mentioned. Thank you.